Thank you very much. Whether or not I'll go over my 15-minute allocation and go back into the full half hour that's probably available, we'll wait and see. Who knows, maybe we'll get some questions at the end. I'll just move over and get the little clicker. Save me fumbling around for the right key. So yes, I'm the group manager of the technology team, which really means I'm there in the ICO to help the rest of the office and give them the security and technical expertise that they need to do all of their casework, because they're not necessarily about 414, 15 staff at the moment. They're all going to be technical specialists. And whether you phone them up on the helpline or they go out and give you advice on a day-to-day basis, when they come across these difficult, complicated technical problems, the idea is they come to me and my team and get a far better answer, a far better quality answer, and a more accurate answer than perhaps them trying to go to an internet search engine and find the information out for themselves. So I'm sure you'll appreciate that's a good resource to have in the ICO. So yes, we're going to look at specifically the Data Protection Act and also what that means and how we move into cybersecurity under GDPR. Again, GDPR it's 88 pages long. The security aspect of it is pretty small. It will be quite tightly focused on that security aspect. So if you think by the end of the presentation, think, oh, brilliant, I've covered all of that, you may not be compliant with GDPR. We're just looking at the little bit of security. There we are on the right slide. So, just to give you a bit of background, so the ICO were the independent regulator or independent authority set there up in the UK to uphold information rights in the public interest, promote openness by public bodies and data privacy for individuals. There's a sort of mission statement. 5 different bits of legislation we actually cover, 4 of which particularly stemming from European legislation. Now, we've both got an education role, but also an enforcement role. I think it's quite important to acknowledge we do both. You can learn a lot more about compliance from advice and guidance that's available on our website, but also from the publications we put out about our enforcement action. We mentioned the one today that was probably done under the Privacy and Electronic Communications regulations. So again, if you're into that habit or in that area of sending out marketing messages by text and email, there's a lot of information available in there. I don't think it's been 100% confirmed, but I think we're probably 99.9% likely to be that enforcement regulator under the GDPR as well. We do actually need a specific bit of legislation to put in, I think, to make us that enforcement body. But certainly we've been doing it for nearly 30 years under the various data protection acts. We're very likely that we'll be doing it under the GDPR as well. I think you probably again also know us from our civil monetary penalties, the amount of fines we do issue, again under the Data Protection Act and Privacy and Electronic Communications regulations. Last year we issued 2.5 million in civil monetary penalties. Some of those are security related, and we'll get into a bit more detail on those as well. So if we look at the current legislation, there are those 8 principles of the Data Protection Act, which I'm sure you can all recite. You all know them off by heart, so you all get a gold star for those acknowledgements there. I suppose to clarify, it is the law of the land at the moment. It is the law that is in force and remains to be so until May in 2018. And then the general data protection regulation will come into force. And the focus of my presentation is up here in the top right-hand corner. Principle 7, that information must be kept secure. But I think recognize, certainly with the other 7 principles there, a good IT system and good cybersecurity will actually help compliance with all of those other principles. So if you've got a good IT system, you can keep data accurate and up to date. Principle 4 there in the middle. You're going to allow data subjects access to their information and uphold their information rights more effectively. If you've got a button on your website that says, contact us and get a copy of your information, it makes it very, very easy for individuals to do that under Principle 6. Talking about the cloud, thinking about international transfers and under Principle 8. Again, a good IT system will keep you compliant with that legislation. And also around Principle 3, so information is adequate, relevant, and not excessive. If you've got that good IT system, that good IT governance, you're making sure you're only processing the data that's actually relevant for those particular purposes. How many backups do you have stored across the organization, for example? Or how many excessive or very large logs or activity, web logs and things like that, are you storing unnecessarily? So you can think about what is security. I think you'll all be aware, everyone has heard of the CIA, confidentiality, integrity, and availability. This is all wrapped up in that Principle 7 of the Data Protection Act. So technical and organizational measures are taken against unauthorized, unlawful processing of personal data and against accidental loss and destruction or damage to personal data. So looking there about that confidentiality, that integrity, and also the availability. More specifically on the availability, if you did delete it, can you get it back in some way? Or if you lost access, can you restore that access? So really, ultimately, if you can do this and ensure that the same level of protection is applied to any personal data that's being processed on your behalf by a data processor, then compliance isn't going to be that burdensome. But certainly thinking about when a breach may occur, the start of any breach investigation so that me and my team will be involved in, we'll start with a series of questions looking at those basics and the IT security and the controls which were in place at the time. So as an example, again, these are things that you can be thinking about in your organization. If you lost a laptop or a CD in the post, for example, then the kind of questions I'm going to be asking, well, was it encrypted? What algorithm and software did you use? Where was the password? What was the password used for that encryption? Was the password disclosed in any way, and how? Was it in the envelope with the CD, for example? Was it actually authorized in the first place to be outside the office? Was that, what was the actual data that was lost? And do you have another copy? And again, think about all of those things you need to be answering, or I'll be asking you, and think about how those answers will come back. And can you prove all of those answers? If you can just say, yeah, it's fine, don't worry about it. Really? That's not a very good answer. It's not going to keep me happy. Again, thinking about a website, if that was compromised and the attacker gained unauthorized access to the data. Thinking, how did it occur? Was the operating system, the web framework, content management system plugins, were they up to date? Was the administrator password compromised in some way, perhaps through social engineering? Why didn't you notice before you phoned up the ICO? Why wasn't administrator access restricted by IP address? Why didn't the administrator log on use two-factor authentication? What data was exfiltrated? Again, how were user passwords stored in that online system? Why didn't you know that the 3-digit security code of your credit card transactions were being stored in the back-end database? And what was the date of your last penetration test and vulnerability scan? Where's the latest report? Why didn't you fix that one that marked red? So again, it's thinking about what are those answers you're going to give to the investigator when they pose those questions. So think about, again, what does compliance look like today? So we'll have a closer look at what the ICO expects when we look for what is appropriate technical and organizational measures. And it comes back to the very start at the very beginning. Where do we start with compliance? There was a hint of it, certainly in the previous presentation. You need a knowledge of all of your assets. If you don't know what you've got, you can't secure it. Thinking about all of those particular assets you've got, those laptops, mobile devices, servers, switches, firewalls, thinking about what software version are installed on each of those. But also thinking about the physical assets as well as the virtual. We've certainly had breaches in the past reported to us, and we've issued also monetary penalties for also loss of physical assets, even paper. There's a couple of organizations have decommissioned buildings, moved out of premises, and left filing cabinets and data left in those premises. So again, it's not just all about CDs and bits and bytes. Again, think about those servers that are on the premise and also those ones in the cloud. Where are they? How are they stored? So once we know where everything is, do you have a secure baseline amongst all of those assets? Do you actually know that when they were shipped out of the IT department, they were secure? Because then if you're not starting from a secure position, there's not really any good way of being able to maintain that. So are all the laptops and mobile devices encrypted? Do you have proof of that? How do you keep that software, or was all the software up to date when it was shipped out on all those servers and all of those desktops and laptops? Is the antivirus or any anti-malware you're running, is that still up to date? Or did you sufficiently test that website before it went live? Again, another issue we're seeing cropping up quite a lot is when a data processor or a contractor created a website and the data controller goes, yeah, okay, fine, it looks good. It looks, the logo's the right color and the font's the right font. Just put it live. What they haven't done is actually do enough end-to-end testing. And the data controller thinks that the web developer does it, and the web developer thinks the data controller does it, so that testing is falling by the wayside. So now we know where everything is. We know everything is secure. How are we going to keep that secure for the future? How are you going to roll out those software updates? How are you going to do those penetration tests, either on an annual basis or whatever is most appropriate? how are you going to do those upgrades to software? And how are you going to monitor the activity on your network? What about suspicious logins? How are you going to know whether or not there's been unauthorized, even physical access to those machines? Also think about monitoring your employees. And this is, again, a tricky area in the Data Protection Act because it can be quite a fine line between monitoring for data protection purposes and maintaining that security, but also going into an excessive monitoring and certainly a covert monitoring the employment workspace. So again, it's another thing to be thinking about. Now, coming back to organizational measures, user training, employee training is going to be a critical component of this. Can they recognize those kind of attacks that they really should be able to recognize, the phishing or the social engineering? Or are they aware of the policies that you've spent hours putting in place? It's no good having a policy and putting it in a filing cabinet on the wall if no one's aware of it or following it. Again, thinking about those policies, actually, how have you ensured that people are following it? What kind of auditing are you doing? And the final one I've got on my list, things about disaster recovery. You know, what kind of backups do you have in place? Have you actually tested them? Or some kind of breach response plan? You know, going through and making sure that it is effective, it is up to date. So thinking about, you've got all of that stuff in place today, haven't you? Good. So that's what, you're all nice and compliant as we are today. So think about, what does compliance look like under the GDPR? So we've got Article 32 of the Security of Processing, which defines you've got to have that ensure a level of security appropriate to the risk, including, as appropriate, pseudonymization and encryption of personal data, the ability to ensure the ongoing confidentiality, integrity, and availability and resilience of processing systems and services, the ability to restore the availability and access to personal data in a timely manner, and a process for regularly testing, assessing, and evaluating the effectiveness of technical and organizational measures. So I think certainly in the context of IT security, GDPR brings, I think, what some people will put in perhaps basic good and best practice really up to a legal minimum. I think some people will struggle to get up to that legal minimum because they weren't doing the types of activities we talked about on the previous slide. Certainly if you're doing all of those and making sure you've got good records of that activity taking place, in a good position to demonstrate accountability or IT security under the GDPR. I think the biggest problem we're going to see is those 69% of businesses, which were in the government's recent cybersecurity risk survey, said that their senior management considers cybersecurity to be a very high priority, but only half of those have actually taken recommendations or to actually identify what those cyber risks are. Again, I think it's very much those that are going to do very well under GDPR and cybersecurity and those that are not. But certainly getting it wrong will be very costly. The penalties within the GDPR looking up to 4% of global annual turnover for when things go wrong. That's also, you're not necessarily going to be able to get away with it, because there will be compulsory notification of those data breaches to the ICO or to the supervisory authority, and potentially notification to those individuals that have been adversely affected. But I don't want to paint a picture of doom and gloom, because we talked about IT security basics that'll put you in that good position if you don't have them in place. There's a lot of evidence out there and a lot of case studies of where people have got it wrong. So let's look at those and learn how to protect yourselves. And also a lot of the tools that individuals are using to attack your websites, your infrastructure, are freely available online. So if they're doing it, using those tools to scan your websites, well, why aren't you? Why aren't you finding those vulnerabilities that are being exploited? One example of getting the basics right is the Cyber Essentials, the scheme put together by the government, looking at those really basics, those firewalls, that secure configuration, access control, malware protection, and patch management, getting all of those basics in place. And see, the report on the right-hand side is the one on our website. It's about 2 or 3 years old now. And the threats described were those that were frequently occurring in our breach, self-reported breaches. And certainly when I wrote the report and got that list of problems that we kept seeing, there's a huge overlap with things like the OWASP top 10 or any other sort of top 10 list of vulnerabilities. So we keep having and seeing SQL injections being reported to the ICO. Things like poor password choice, poor password storage. In a very poor sort of update and patch management policies. Again, organizations are failing to do this and then being caught out, being discovered, by those automated scans or perhaps a more targeted attack. But again, thinking about, you've got your IT infrastructure in place, what about those cloud storage services as well, that data that's outside maybe of your absolute direct control? So again, thinking, why are we so bad with cybersecurity and failing at those basics? I'll give you a list of some of those recent mistakes. TalkTalk, being the most recent and high profile, issued a penalty of £400,000 because there was an SQL injection attack against part of their legacy infrastructure, gave the attacker a route in to their core infrastructure. £150,000 loss against RSA, the insurance company, for a loss of a backup drive that was in what they thought was a secure facility. And that drive was able to be lifted out and taken away and not found. Blackpool Teaching Hospitals issued a penalty of £185,000 for inadvertently publishing personal data on their website. And the Money Shop, £180,000 for inappropriate security, again resulting in that loss of physical equipment. So again, if we can get these basics right, we can certainly avoid most of those penalties at least. And also thinking about GDPR, those numbers will only increase. Now again, we talked about guidance at the very beginning, so you can look at our website. We've got a specific section all about GDPR, and as guidance comes available from the European Data Protection Board, that will also be linked to from our guidance. Unfortunately, it's not a particularly snappy URL to reel off, and I didn't want to leave you a bit.ly link either. But certainly, I don't know, if you go to the ISO's website and put GDPR into the search page, that will come up as the top link. So as a quick summary, be prepared. There's a lot of knowledge available, both in this room and through the forums that I'm sure you're all members of. Why are you not checking your organization against those other questions that your peers are asking? And cover those basics well. Get that software updated. Get that mobile data encrypted within your premises if it's appropriate. Look at that access control, specifically around password reuse as well. Individuals are very bad with passwords. Let's at least acknowledge that and try and protect that data in other ways. Think about what kind of monitoring you're going to be doing. Will you actually notice if a breach happens? Or will you be informed by a user who says, well, my card's blocked and I made a purchase on your website last week, or your payment card provider phones you up, or whatever it might be? And that monitoring, that testing, and importantly, audit, practice and learn. Do learn from those near misses and keep that up to date. So thank you very much. Okay.
Do we have any questions for Dr. Rice?
Hello. Is that working? That's working now. Hello. So obviously, pseudo-anonymization and encryption are specifically referenced in the GDPR as a technical control that companies should look at. I was just wondering how you guys were interpreting that. Is that seen as or could you interpret that as encrypt by default, or is it more nuanced than that?
I mean, I think I think there are certain instances where encryption, you can say, is almost mandatory, or very, very not sensible to do it in those particular circumstances, especially when you think about mobile devices or USB devices, or you're sending data in the post, or trying to do a login on a website and sort of processing beyond that login. You can think, well, why wouldn't you encrypt it in those circumstances? Especially if there is no, I suppose, detriment to the organization in a way. There's not necessarily any kind of processing detriment that there might have been many years ago. I think at the other end of the scale, there's instances where it really can't be done, technically. If you're opening up an Excel spreadsheet, generally you've got to decrypt it to actually do that processing, and look at those figures. And in the middle, it's going to be a judgment call. It's certainly looking at the risks of the exposure, what's technically available, and really what sort of means are available to the organization. And in a lot of those cases, it's going to be falling back on that data protection impact assessment. So you've got a new process coming in, you're going to look at it, will be that obligation to do that data protection impact assessment, where it's looking at what data you've got, what are the processing steps, what are the risks, and what can we put in place to mitigate those risks? And encryption may well fall out as one of those mitigating measures. Or you might look at it and go, actually, encryption's going to cost us, I don't know, £5 million, just to pick a number out of a head, whatever it might be. You could make a judgment and say, well, that's too expensive. We'll look at other technical controls. But you might say, well, encryption's not going to cost us anything because either we've already got the software or it's freely available. So then you kind of think, well, why wouldn't you do it in those kind of examples? So that area in the middle is always going to have to be looking at the level of risk.
Okay, I've got a couple of questions, sorry to say. First one, obviously with the UK leaving as part of Brexit, GDPR is going to come in place next year. What is your opinion on where we'll stand as a UK company and being located across 23 countries in Europe? Who do we notify?
I mean, it's certainly my understanding, where it is our legal position at the moment, the GDPR is on the statute book. It is in force. It's just not, or it's enacted but not in force, or in force and not enacted. I can never remember which way round it is.
Not enforceable by law yet.
So I'm not a lawyer, I'm on the technical side. But it certainly will be applicable in the UK on May 2018, 25th of May 2018. And I understand the Great Reform Bill, as it's going to go through Parliament, will make that a UK bit of legislation. So in June 2018, it'll be the legislation that it's in force. Quite what happens 2 years, 10 years after that, I haven't got a crystal ball.
It's notifying authorities is my concern.
The notification, I mean, if you're established in the UK, and if you thought the UK was your main establishment.
But we're not part of the EU.
I mean, under that, you would, even if the Brexit debate wasn't in place, you'd be still notifying just to that one individual supervisory authority. You may need to notify to customers affected across all of the EU. But as I understand it, that notification will come to just the one data protection authority. I will caveat that by saying when our guidance comes out, it will be very clear on that point. But also under those kind of points, we have to cooperate with the European DPAs to get that one single vision, because obviously you don't want us saying one thing and the Belgians saying another and the Germans saying another. So that will come out. That's breach notification is in the work programme for this year, in the 2017 work programme of Article 29. So the guidance should be coming out at some point this year. I think it's around about September as a vague work plan.
Okay, cool. The second question is, if you're a company that outsources to, say, China or Malaysia or something like this, obviously at the moment we might not have the requirements as they're only data processor. At that point, they are responsible for that data. How are you going to, in the event of a breach by them, how are you going to monetize that claim back from them?
I mean, certainly under the GDPR, if they're a data processor, they will have that legal obligation. Looking at who is responsible, we'll also be looking at, well, what controls did you have in place or the legal structure in place? If you had the obligation to be monitoring that processor and didn't, then clearly that's your failing, versus if they just went off and did their own thing, that's going to be their failing. I mean, there's nothing stopping us issuing a penalty or enforcement action, whatever that might be. I guess there's difficulties, as there are in any international legislation, on actually collecting that fine or enforcing that. But we can work with our international counterparts to assist with that.
But if that country's got no regulation, if you look at their regulation, it doesn't actually cover anything from any data outside their territory.
Then I'd have to ask, what controls have you put in place under your obligations of international transfers to protect against that? And that will either be some sort of self-assessment or model clauses and that kind of thing. And that may be that then the obligation lays back with you.
Cool. Thank you.
Part of my company works in the education sector. I would suspect if you go into any school in the country today, you'll find endless breaches of the Data Protection Act. It's almost impossible for them to comply. They've got reducing budgets, an increasing reliance on ICT, increasing amount of ICT based on the internet. Most primary schools, for example, probably have about 3 hours of IT support a week. Teachers, therefore, are left to their own devices. They have a tendency to use memory sticks, Dropbox, all sorts of other sort of unauthorized means of transferring data. They might just do it to bring in a YouTube clip, but it's quite attractive to drop their annual reports on there and work on them at home. How on earth, when the budgets are so constrained, can you expect the education sector to actually meet the requirements of the Data Protection Act?
I mean, I think first of all, I'd say those concerns are probably not limited to education, widespread across even private sector, potentially even the public sector. First of all, I can start off and say there is no exemption in the Data Protection Act or GDPR for I didn't know it was too difficult or too expensive. Or maybe too expensive under what is appropriate. So there is no defense, unfortunately. Well, in one way, fortunately. And ultimately, that responsibility will lie with those schools as data controller to make sure they have the right security in place. Yeah, we do work with education authorities and central government to try and push that down in the same way that we will work with all other organizations to try and maintain that security. But ultimately, it will be their responsibility to keep that up to date.
I mean, just if I can come back with a little supplementary in that, the data controller is normally perhaps the school secretary, maybe the bursar, or a school business manager. And in terms of ICT, it's a teacher who's given that as an additional job with no training, probably with little or no knowledge of ICT. So are you pushing, as the Information Commissioner's Office, government to provide that funding into sectors like education, and I appreciate it's other sectors as well, to provide the funding to make sure people can be compliant?
I mean, we're certainly pushing the message that everyone needs to be compliant, and central government is well aware that cybersecurity needs to be improved across all industries. So yes, I mean, we are working with them on cybersecurity in general, not specifically a particular focus on education per se, but all industries. Okay, one more?
I don't think this is working.
I can hear you, so it must be.
Everybody else may not. Simon, thank you very much for splendid content in a short time. Personally, I wish you'd had longer. We've got a new president of the United States, as everyone's noticed. We've got a relatively new prime minister. It may have escaped some people's attention, but certainly not yours, that we've got a new information commissioner. And she is North American. And we've got a new European piece of legislation, which you've touched on, the GDPR. I think that the website and the educational initiatives by the ICO are tremendous. What is very, very confusing is why there isn't a bigger take-up, not just in lip service to cyber resilience by business and the supply chain, but actual, real, meaningful protective measures. The insurance industry complains that there are 60 providers out there, but not enough customers. They're providing breach response products, they're providing education and training, but they're not getting enough business. I imagine that in the privacy of government and those who advise government, that there will be limited tolerance on whether we use more of the carrot or actually it's time to get the stick out of the cupboard. And I'm thinking TalkTalk, where 80% of the limit of fine was used by the current Information Commissioner in a £400,000 fine. I think if you gross that up into GDPR equivalent, it would be pretty difficult to explain 55 million, which may upset some stakeholders. So I'm sorry it's a long question, but do you see more stick and less carrot? And I wonder in our community here what our CEOs and directors are doing meaningfully, and will they listen when they're hit in the wallet? Because the Parliamentary Committee on TalkTalk, I believe, recommended that CEOs' compensation be affected if their organisation was less than diligent in terms of cyber security. There's a lot out there. Why aren't people doing more? And is the ICO going to get the stick out?
That was about 5 questions, and you've got
I think I'll go for the
There's
first one and the
more.
last one if I can. I can choose which ones I answer. Why is, in your words, to paraphrase you, why is IT security so bad? I'm going to have to push that back to the audience and say, well, why is it? Why haven't you improved? Why are your organizations failing again and again and again? Why do I keep getting breach reports about the basics? Why are there still SQL injection attacks? Why are you still storing passwords in MD5? Why are you still allowing me to log in without using SSL or TLS? There are those questions I'll fire back. Will there be more stick? There may be a bigger stick. There will always be a proportionate and reasoned approach to any monetary penalties or use of our enforcement powers. I absolutely guarantee that. It's not going to be a case of submitting a breach report to the ICO and there's an automatic penalty in the return post. You know, we have to exercise our judgment. We will have to look at the facts of the case. We will have to look at whether or not you had appropriate measures that were in place. It doesn't say in the GDPR everything must be 100% secure, locked down, you know, stored offline and in concrete, because ultimately that's going to be the only way you're going to get that. It's still going to be looking at the facts of the case and whether that was appropriate for your organization. And thinking about that appropriate, well, if you're one of the big 6 technology providers, internet service providers, your technical skills, you would imagine, are going to be better than, you know, Joe the plumber round the corner. So again, it's that on that scale of what's appropriate for your particular organization and what you've got in place, what your obligations may be.